Hi, my name is Marla Schechter. I'm a U.S. immigration lawyer based in Los Angeles, and I represent individuals and corporations operating all over the world. What I want to talk to you today about is growing your business and expanding into the United States. Okay, when I hear from clients operating overseas about their businesses and their plans for expansion, very often I hear the remark that they can't really expand their businesses until they create a presence in the United States. They've maxed themselves out in their home countries, and the US, with its huge consumer base at both corporate and individual, is really the place to be. And they know that when they begin operations here, they can't just have a US company run by US individuals or run by some other company. They have to actually set up a US office. They have to rent office space and get some of their key personnel from abroad transferred to the US to begin operations here. Short of that, they don't feel comfortable and confident about being successful here. Okay, the key to any successful business is the people that represent you here and that are operating your business. And so bringing people that have worked in your foreign business to the United States is essential. Okay, now there are two different non-immigrant visa types that are appropriate for this scenario, starting a new business in the United States. One is the L-1 and one is the E-2. The reason I'm starting with non-immigrant visas rather than immigrant visas is because you can get them a lot faster. Immigrant visas can literally take a year or more to process, and sometimes they're not even appropriate for the scenarios we're talking about here. The much easier is getting a non-immigrant visa, and then after you're here and you've developed a successful US business, then changing your status to that of an immigrant. Okay, so we're going to look at the two key non-immigrant categories that are designed for this particular type of purpose. The first is the L1. Okay, and L1 is for intra-company transfers. When you talk about intra-company, it implies that there is a foreign business as well as a US company. So what we're actually talking about here is starting the new US business, but having a successful company operating abroad for at least 1 full year. Why does it need to have operated for 1 full year? Because one of the requirements is that the personnel that you're trying to transfer has to have worked in the foreign company for a full year before transferring to the United States. And you're going to have to prove that in the application, okay, through payroll records and, in the case of Canada, a T4 or something like that. Okay, so the foreign company not only has to have been in existence previously, but it has to remain in existence and operational the entire time the transferee is in the United States on L1 status. Okay, so that's something that's very unique to this type of visa. It's the only one that requires there to be a foreign company operating previously. So as part of the application as well, the Immigration Service looks back at that time that the individual spent. It has to be 1 year within the previous 3 years of coming to the United States or filing the application. And they look at what that person did, who they managed, how much money the company was making, and a number of other factors. Okay, so it's important that it have been a relatively successful company operating abroad for at least 1 year. Okay, next issue I want to talk about with respect to L1s is that the two businesses, the US and the foreign company, have to have the correct qualifying relationship to one another. What does qualifying relationship mean? Well, that's defined as basically the two companies being controlled by the same shareholder, group of shareholders, company, etc. Okay, when you look past corporate form as to who actually owns these companies, you have to find common control between the US and the foreign company. There are only 3 kinds of personnel you can transfer on an L1 visa. One is manager or executive, and that goes toward the category of L1A visas. And then there's a specialized knowledge individual who will then apply for an L1B visa. Okay, a manager or executive are people that have been involved with a foreign business and have managed, in most cases, other people. There is a category for having managed personnel or manage a function within the company, the foreign company. But even in that case, you ultimately have to show that other people are the ones that are producing the bottom line service or product that the company is in business to produce, okay? So it's generally other people that need to have been managed, and they're coming into the US also to be a manager in most cases. Although that's not essential. A former manager from the foreign company can be coming into the US to be specialized knowledge. The word specialized knowledge, that phrase, is defined as someone who has particular knowledge of the way that the foreign company does business, their products and services, their processes, etc. It's not something that you can hire a US worker, even if they are if that individual has worked in the same industry or even with the same type of products. If they haven't worked for the foreign company of this same company, basically the foreign office of the same company, they won't be able to do the job. And you've got to prove that in your petition. So I find that L-1Bs are a lot, go into a lot more detail. I spend an elaborate amount of time, an extensive amount of time, I should say, in discussing and interviewing the owner of the company or the manager that I'm speaking with to understand exactly how it is that the individual has that specialized knowledge. Very important that broken down and discussed in elaborate detail in the petition. Okay, L-1As get 7 years to be in the US. That's including various different extension petitions. You don't get 7 years all at one time. It starts with, for a new office, you get 1 year. Then depending on where you process the renewal, either at a port of entry, some port of entries will give 3 years, some will only give 2, and the U.S. Service Center that also will process L1s will only give 2. One key advantage that Canadians have is that they're able to process their L1 visas at a port of entry or at pre-flight inspection in the United States. And that can make a big difference. So just speaking kind of away a little bit from the actual requirements, just into how these things are actually processed, I will say that, and this is something that the U.S. Immigration Service is trying to deal with now, creating a system whereby every applicant for an L1 has an equal chance of getting it, meaning that that there's consistency in processing across these different ports of entry and the service centers. You'll get a consistent result. But right now, quite honestly, that's not the case. Okay, depending on where you go to which port of entry, you might be more likely to have it approved than other ports of entry. Okay, I've been doing this a long time, a lot of Canadian companies, and that has been my experience. And any other immigration lawyer you talk to that deals with a lot of Canadians at ports of entry will tell you the same thing. So that is something to be very sensitive to. It's not just how it's processed, it's by whom it's processed, okay? Last item that I really want to discuss on the L1 front is that there is a virtually identical immigrant visa category. You're going to want to be pretty successful in the U.S. before you apply for that, but it does exist. So that's something that you can segue into once you're already in the U.S. There is one other element that I wanted to discuss with respect to the L1, and that is there's no minimum investment amount that has to be made into the U.S. business. You do have to have a couple of items when you go to apply for your new office, L1, and that is a business plan. It doesn't have to be professionally prepared, although there are many companies in the U.S. willing to do that for you. They come out great, but it can be done very successfully on your own too, particularly for native English speakers or people with very good English skills. I provide a template of what needs to be in a business plan and an example of one that I've used successfully in the past many times. And then people are usually able to adapt that and create a business plan on their own, and I help edit it, okay? So that'll save you $2,000 or $3,000 right there if you prepare your own business plan. But that's an essential component to a new office L1. And the other thing is a commercial lease, okay? A lot of people in this day and age, particularly when they're starting a new company and they have limited resources, they want to devote those resources to things that really matter. Like buying inventory and investing in office equipment and this sort of thing. But you also have to have a commercial lease, okay? The Immigration Service hasn't caught up to the fact that a lot of U.S. business people or business people operating anywhere operate from their home remotely. They operate from shared office spaces like WeWork. They don't particularly appreciate that kind of scenario, and they really want to see a commercial lease. So let's not try to convince them that your form is really a better form or just as good as this says it's commercial lease. Just get the commercial lease, and you'll be in much better shape in getting this approved. Okay, so that's the L1. Let's move into the E2 now. All right. The key thing on an E2, one of the key requirements is that there must be the requisite treaty between the U.S. and the country of nationality of the investor. Okay, so there are two, just so you know, and I'm not going to talk about the E1. There's the E2, which is an investor visa. There's an E1, which is a trader visa. That's for someone that's doing business and trading, creating a product that's doing a lot of trade between the U.S. and the home country. We're not going to talk about that one so much, but both of those rely on the requisite treaty. And some countries have it for just the E2, some have for both the E2 and E1. So if you're starting to think about an E2, the first thing to do is to look up that country, the home country, and you'll see whether or not their treaty exists. It's very frustrating for a lot of people when it doesn't exist, but there are sometimes that's sometimes when you use the L1 is because you just won't make it on the E2. Okay, you won't qualify. Once you know that the treaty exists, then you can look at whether or not the investor is say they want to invest not just their own money, but they want to invest perhaps the business that they own in their company abroad. They want to invest the company's money. Okay, so then you have to look at who are the shareholders of that company and whether or not at least 50% of their shareholders share the treaty company's nationality, the treaty investor's nationality. Once you've met the requirement that a requisite treaty exists between the foreign individual, country, nationality, and the U.S. And the United States, then you also have to sometimes look at if the individual is not going to be investing their own money, but they're going to be investing their company's money, who are the shareholders of that foreign company, and do at least 50% of the shareholders have the same nationality as the country we're talking about here. Okay, so that's an essential thing to look at as well. Okay, one of the key things to keep in mind is that there does not need to be a foreign business with respect to E2s. There does, of course, again, with the L1, but not for the E2. And even if the individual does have a foreign business, sometimes they don't want to use it. They can already foresee that once they get established in the U.S., they're likely to be very successful there. It's going to be too difficult for them to divide their attention between operating in the U.S. and operating still back in their home country, particularly if there's plenty to spend most of their time in the United States during that time. Okay, so they may not want to get started on an L1 when they can already foresee that they're going to want to probably close their foreign company. Okay, if they don't intend to ever close their foreign company, then the L1 may be the perfect vehicle for them. And then sometimes what people end up doing is they're not sure how things will go in the U.S., and so until they know they're successful, they'll come in on the L1 because it can be adjudicated right at the border, doesn't have to have a minimum level investment. They'll get in on the L1. And then after a few years, once they're very successful in the US, they'll look back and say, gosh, it's just too much to try to manage and keep up the Canadian business when really most of my business now is happening in the US. So I'm going to close that foreign business and I'm going to switch my visa from L1 to E2. Okay, I've had that happen many times. All right, next requirement. Once the new U.S. office is open and say the investor, he or herself establishes the E2, registers the E2 company with the U.S. consulate, then additional personnel can be brought over with minimal paperwork. So that's a nice feature. For the L1s, you've got to submit everything all over again with each individual that's coming from that's transferring from the foreign company to the U.S. In this case, first of all, you don't have to have individuals coming from any foreign company, just an individual that shares the nationality as the investor. Okay, it has to be the same nationality, but it can just be a colleague you may know from work. You maybe never worked with that person before, but you know that they're an expert and they would be critical to your success in the U.S. So you can bring that person on as an additional person on the E2 that has to show minimal paperwork after you've gotten the initial investor in, showing the more extensive package. Okay, so let me just go back to something I alluded to, and that is where E-2s are processed. In most cases, they are processed at the U.S. consulate in the individual investor's home country. And the individual investor can come into the U.S. on a B-1 visa to look for a location, to meet with their corporate lawyer, to get their corporate format set up, to do whatever else due diligence they need to do in the way of due diligence. And then they go back and apply for that U.S. Visa at the consulate. And then they enter on their U.S. E-2 visa, okay, that's stamped into their passport. So even for Canadians, they must go to the U.S. consulate. They can't do it at the port. They can't process directly at the port of entry. And so most E-2s, now when I say most, there is an option to do it if you're already in the United States. You can apply for an E-2 with USCIS, but you will only get 2 years versus 5 years for a Canadian, and different countries give different amounts of time, but that's a pretty big difference. It gives you a lot more time to get operational, especially if it's a brand new business, a new office, you're not acquiring that business from someone else. It gives you a nice chunk of time to hire personnel, to develop something in the U.S. before you have to apply for renewal. And then another key difference between the E-2 and the L-1 is for the E-2 for renewals, you do have to go back to the consulate, but it's a much simpler process. If your company is still registered, which it should be from your initial registration, you show a couple of tax returns, payroll records, and a few other small details, and very often you don't even need to show up for the interview. Okay, they'll waive the interview requirement. So that's a nice feature of the E-2. Some of the requirements for an E-2 visa. One, and this is a key difference between the E-2 and the L-1, is there must be a substantial investment in the U.S. company. The big question is, what does substantial mean? It's not defined in terms of a minimum dollar amount, okay? Every business needs are different. The consulate will look at the needs of the new U.S. business, how much capital has to be put into the business so the business is fully able to open its doors and begin operations. And then they'll see how much has been invested. And so there's a sliding scale kind of test. If the business only requires, say, $250,000 to begin operations, and the individual's invested 200,000, so almost, say over 80% of that amount, that's probably going to be considered enough, okay, a substantial investment, and maybe they took a loan for the 50 remaining. If, however, a company is trying to create a $10 million business and the investor has put in $1 million of his own money, that $1 million is at risk, and they know that individual is going to work their hardest to make the U.S. company successful, to direct and develop the U.S. company into a success, even though they haven't invested they've just invested 1/10 of the total overall amount. So again, it has to do with the scope and size of the U.S. business you're creating and what the needs are of that particular business. And again, a U.S. immigration lawyer should really be able to discuss that issue with you and help you understand how much money you're going to really need to be investing for the type of business that you want to create. Okay, so that's one thing. In terms of not just how much you're going to need for the substantial investment, but what you need to put it in, you actually have to be in the process of investing or have invested. It cannot be completely prospective. In other words, you can't say, well, I've got $500,000 here, and I'm going to, when I come in and get my visa, then I'm going to start putting it into the company. It doesn't work that way. You have to have already invested in the U.S. company. You can show that investment through prepaid office space, prepaid employees, payroll. You can show through investment in office furniture and redevelopment of office space, or inventory. All of those things can go toward the actual the investment that you need to show. Okay, so generally what I do is I create a spreadsheet and I have every item listed that's over $500 or $1,000 that we're going to show as being a contribution to our substantial investment. And each one of those items will be, a line item with the amount set forward, and then I'll back it up with the invoice or the receipt that was issued for that payment, and then a proof that the payment actually occurred. So you need a lot of documentation, a lot of supporting documents for the E-2 to be successful. So if you're going forward and you haven't started, please put everything, every receipt that you've used, every payment you've made that went into the U.S. company, put it all in a folder and save all of those receipts. You're going to need them. Okay, the next thing that is examined by the officer that's adjudicating your petition is the source of funds. Where did that money come from? So the money has to have come from some sort of legitimate business activity abroad, or it can be through a different business in the U.S. It doesn't have to come from abroad necessarily, but generally people will show that, for example, they earn the money by selling a property. The proceeds were transferred to one account, and then from that account it was transferred to the U.S. new business's account. So you have to show every step of that transaction to prove the source of funds. Okay, sometimes it gets a little complex, other times it's quite simple, but that is another key requirement of the visa. The third major requirement is marginality, and the issue here is that the business cannot be so marginal that it's only in existence to support the investor and his or her family. It also has to be able to support at least the equivalent of 2 full-time employees. Okay, when I say the equivalent of full-time employees, that means that it can be 4 half-time employees, so that would be the equivalent of 2 full-time. And again, you don't have to show that this has already happened. You don't have to have any employees going in when you apply for the E-2, but your overall budget that you're going to show. You're going to show a pro forma budget over the coming 3-year period, at least 3 to 5 year period, and you're going to show when it can start supporting more individuals and what your hiring plan is. Okay, for the next coming 3 to 5 year period, and when you'll eventually be able to support new personnel. But that's going to be a key requirement when you go to renew the E-2. They're going to see that employees have been hired by the business, and it should happen as early on as possible in the course of starting your new business. Again, for a new office scenario for the E-2, you're going to want to show a business plan as well as a commercial lease. And the business plans are essentially the same as the business plan for an L-1. Okay. A nice feature of the E-2 is that the 5-year period, say in Canada, whatever the period that you're getting from your home country is to be in the United States, you're allowed to keep renewing that indefinitely. Whereas for the L-1 and the L-1A and the L-1B, you have a total of 7 and 5 years respectively total to be in the U.S. If you're there on a full-time basis, you need to be gone after year 7 and home in your home country for a full year before you come back. In this case, you can keep staying in the U.S. 20 years, 30 years indefinitely by continuing to renew your E-2 whenever it comes up and whenever it expires. Okay, so that's one key difference as well. E-2 and L-2 spouses, so in both categories, spouses are permitted to work, not children, not dependent children, but spouses are able to get open work visas, which is really nice for them. You apply for those separately through the USCIS in both cases, and the spouse gets the same period of time to operate as the primary investor. Okay. Unlike the L-1 category, there is no identical immigrant visa category with respect to E-2s, but there are different things that can be done to move into an into an immigrant visa category when that time comes. Again, you probably want to establish a very successful U.S. business before you think about doing that, and keep all of your receipts and all the expenses you've brought in from outside the company. Okay, you can't use operating funds from the U.S. company to then reinvest into the U.S. company. It has to be outside funds. Okay, so I hope this was helpful. It's some of the key differences between these 2 non-immigrant visas that are designed to help companies and investors operating abroad start new businesses in the U.S. I'm happy to speak to anybody. I offer a short free consultation and then a longer paid consultation about any of these issues or about others as well. And feel free to reach out. Good luck with your expansion plans.